Should we start?
Yes, yes.
All right. A very good evening to all of you present here. We have Mr. Subhash Vashishtha with us today. We have had a wonderful and highly informative bunch of lectures with Sir over the last few weeks of the course. For the benefit of the participants, I would like to introduce our esteemed resource person. Mr. Vashishtha is an advocate and the Joint Secretary at the National Association for the Blind. Today, we all are here for the 16th lecture of the Disability Studies Certificate course jointly organized by the NCPEDP and the CDRT. The topic for today's lecture is access to justice, challenges, barriers, and solutions. I now hand over the mic to our resource person to start the session. Over to you, sir.
Thank you, Akshay, and the NCPEDP team. Sorry, I just did not notice your name, but then thank you so much for introducing me. Another opportunity. Thank you, Arun Rao, the wonderful interpreter. So the topic that today we have is access to justice. Very, very important topic because I think our lives are connected so much to the access to justice every day. So today I'm not going to be showing any presentation. I'm just going to be talking, and I'll be talking slow as I'm aware Mr. Rao is otherwise going to be reminding me that speak slow. So I'll take care of that. So I'll begin with what is access to justice. In very simple terms, what is access to justice? So I'm sure one or two of you can speak if you want. Before I elaborate on that, would you like to? Somebody want to make an attempt? Just one liner? Anybody? No? Okay, well, if you're still coming on to it, then let's continue. I wanted this to be a little more interactive so that I get to know the understanding of yours about this and what do you think about this. Nevertheless, access to justice in very simple terms, I would say, is the equal ability to be fully heard and to participate in all aspects of justice system without discrimination on the basis of disability. I mean, to me, this would be access to justice. So you have the equal ability to be fully heard and to participate in all aspects of justice system without discrimination on the basis of disability. Why it is important? Why it is so important? See, guaranteeing access to justice is indispensable to any democratic governance, especially in a country like India, and also the rule of law. And needless to say that to combat inequality and exclusion, this is very important because very often the inequality and exclusion happens because of lack of access to justice. Our experiences on routine basis, we find when we face discrimination in access to justice. What does discrimination mean and what does it include? It's simply, when it comes to discrimination, it is bad treatment on the basis of prejudices and stereotypes about disability. Like there's a common belief, people with mental health conditions are prone to commit violent crimes. Now, entire justice system has this belief, and I can tell you my experience. I fought for almost 8 years for a civil servant to be given, or a person who's with mental illness to get into civil services, and the judges would not accept that a person with mental illness can work as a civil servant. So these treatment, these stereotypes, the prejudices, that is a very silent discrimination that is experienced every day by people. What would be discrimination in addition to this? failure to provide reasonable accommodation. That is a huge discrimination we face on everyday basis. We know that we have to overcome as persons with disabilities the historical and existing physical and programmatic barriers that we routinely face. So these historical challenges, physical and programmatic challenges we face on everyday basis. Now, increasing access to justice for people with disabilities would involve, we need to work, and the judiciary and all stakeholders need to work on achieving this fair treatment to persons with disabilities before and under the law. And this would mean providing effective communication. Very often this communication isn't there, especially for people who are hard of hearing, people who have intellectual challenges. This is, or people where communication happens through eyes many a times. Then of course, people with blindness. And we need to ensure that due process is provided to every person with disability in all aspects. Now let's check what are all these various aspects that people come across with the judiciary or with the access to justice system. See, traditionally, when it comes to access to justice system, we believe the persons with disabilities as victims or people complaining about something. So that is often considered as access to justice. But for me, and in general, persons with disabilities are not just victims and complainants. They're often they can be as accused, as respondents. They need to defend themselves. So are there barriers or is there facilitation? Important area. Then persons with disabilities are witnesses of say a crime, or witnesses, simple witnesses of a deed of say somebody's will, and a person with hearing impairment or a person who's deaf has signed as a witness. Now, when the will is brought before the courts for somebody challenges the will, or it goes for a probate in the court of law, the witness is also called. Okay, were you there? Did you witness? Did you sign? Are these your signs? So all that is questioned in the box by the opposite lawyers or by the lawyers of this party who's claiming for a probate of that case. Now, is the system enabled for a deaf person as a witness to respond? I mean, my experience has been very bad. And in fact, in few cases, I actually came forward and alerted the judge that this is wrong. The person hasn't understood the question. He's simply nodding his head. So another aspect is where persons with disabilities as not just as also litigants, as an advocate. I mean, I want to take up a PIL. I'm a concerned citizen. As a concerned citizen litigant, we come across the system of access to justice. I would not stop here. I would add persons with disabilities interacting with the access to justice system also as advocates, as lawyers, as judges. Why should we see persons with disabilities only on this side where they're claiming as victims or defending themselves? They can also be persons who are delivering the justice as judges, or speaking for the fellow being or for other people as a profession, advocates. I mean, how do we find so many barriers? And access to justice would mean looking at all these barriers and removal of these barriers and making the justice system accessible. Let's go to courtroom. Typically the courtroom is the first interface when we look at access to justice. I think even before that, I would come to police stations, especially when it comes to crimes. So we look at police stations, and which is a first step, especially when this is criminal cases are taken up. So the first place whether any person would go to complain or if somebody has filed a complaint against him, then police will call him for interrogation in the police station. Now in police station, overall environment is very threatening, whether you are a complainant or whether you are called by the police for interrogation, as an accused or whatever. Or somebody just an alleged perpetrator of a crime. That yes, you did this, so you need to come and answer it here in the police station. You're called up there for interrogation. The environment is completely inaccessible. I do not know the system. As a person with disability, I'm completely unaware of what are the various processes, what are my rights, how would I be treated, what can I do if I'm treated badly, can I take my lawyer with me, do I have a right to inform somebody, what if I am picked up from my home, and will I have access to my family members with me or somebody who can interpret? Because usually in the police station, there is no sign language interpreter. So you need to make a request, and very often this request is not really acceded to. Perhaps the system doesn't exist. Interrogations becomes, literally a non-functional system or process where the person doesn't understand any question. He is just full of fear. Imagine persons with other disabilities, persons with blindness in the police stations. So because they're able to speak, they're speaking, but they can't see what is being written. Anything that has been said by the blind person and which has been put on the Rojanamcha or the register by the police, somebody might be reading it out and might be reading out wrong. How does the person ensure that what he has stated is written there exactly in the same terms? These are important challenges. Coming to the courtrooms. The first feeling that I get into entering the courtroom is, again, somebody is sitting at a very high seat, and I just need to be adjusting as per the environment, as per the procedures of that. I don't know what is my situation, where will I stand in a typical courtroom. Of course, this also happens with many of our clients, whether he is a petitioner or is a complainant, which side he will stand, whether he has to stand on the right to the judge or the left to the judge. So there are specific procedures in the code of law that person is completely unaware. Now, for him, it's a alien environment. There is no system to explain how the court works and to make the person comfortable when he's attending the court in any form. As a witness or as a complainant or as a respondent. He does not know. The courtrooms are physically inaccessible in most cases. After the act came into being, after the Accessible India campaign, yes, some ramps have been created, but these ramps are again additions which are ad hoc and very, very steep. At many places, they are very steep. They don't meet the gradients. They are slippery. They don't connect buildings seamlessly. So it is very isolated access that is to a courtroom. For example, out of 10 courtrooms, 1 or 2 would only have access to ramp, all others would be inaccessible. And this is situation is much bad when you go to lower judiciary. The district courts or the taluk courts, magistrate courts, or subdivisional courts or JMFC class 1 court. So there is completely no accessibility even today. I just had, I was visiting a court in Gandarbal in Kashmir. Completely inaccessible. I visited another court in 2 months back in Rajasthan, in Udaipur. Some heritage building has been converted into court, no accessibility. Leave that, I'll talk about Delhi, the Patiala House Court. The court isn't accessible because it is this is situated in one of the old building of Maharaja of Patiala where the court functions, and you can't access many floors because the next first floor, because there is no lift. So physical accessibility in the courtrooms is a huge, huge challenge. Then there is sign language interpreters during court hearings is a huge challenge. Today, I was talking to somebody and from New Zealand, and we were having interactions as to how sign language is, the New Zealand has 3 official languages. And one of them is sign. I was surprised. So English, one the local language, and one is sign language. And I asked him how it came, how it happened. And I learned that there was a minister who was deaf. And anything that was said in the parliament, the minister could not get, could not understand. So because of that minister being there, the parliament accepted sign language as a 3rd official language. And anything that was transacted in that parliament in New Zealand, even today, of course, that minister is not there anymore, but because of his being there, the process was created. Any bill that is presented in the parliament, any discussion that happens, everything is simultaneously signed in the parliament. So that has become an official language. We in this country are still fighting for sign language to be an official language. We still have a long way to go. So coming back to India, the next thing is reasonable accommodation is something which is missing in most courtrooms. What is reasonable accommodation? I'm sure in the earlier lectures we studied, we went through the importance of reasonable accommodation, what all it include. Other thing in the courtrooms is pleadings and documents. You know, the lawyers will give you a huge bunch of pleadings. Sometimes it is in a very poor print. Sometimes half print is not visible. If I'm blind litigant or a respondent, I can't answer it. I don't know what is written in that. It can't be read by a screen reader. I have to take some manual help. And worst would be if it is handwritten. Especially in lower courts, most of the things are handwritten. They're not digitized. So I would not know. And also let me tell you the kind of language being used by police to write an FIR is such archaic language. Even best good lawyers who have studied law would not understand that. It is, coming from last 100 years in Farsi and what all terminologies of Farsi and Urdu are being ingrained, that even for us, it's a challenge. So these are, typical barriers that you face during hearing and trials. Then many courts have applications or websites through which you need to interact, because in the Corona times, in the COVID times, a lot of effort had gone into making things virtual. So everything will go virtual. In the virtual mode, I myself had such 2 or 3 such instances where the either clients or who they were deaf or they were blind people. I'm still on these 2 disabilities. You can imagine there are 21 disabilities, and especially if it comes to multiple disabilities, you can imagine the situation. We aren't there. We're talking about access to justice. So access to online and hybrid hearings and interpretations was a huge, huge challenge. In one case, I insisted that we have sign language interpretation. Sign language interpreter was organized for that. But the WebEx system, the internet speed was so slow, or I don't know what problem was it, but then the person who was deaf could not understand the sign itself. Because, by the time you speak, his hand movement wasn't visible. It was so wavy. It looked like very fast some vehicle has just gone past. So because of low bandwidth, because of poor connectivity, or because of many other reasons, the sign language interpretation on virtual access wasn't feasible, could not happen. I'm glad Arunji is able to do it so well, and we have better connectivity, we are able to see him. But then where connectivity is poor, these things also become a huge barrier. Delhi High Court recently, I would say a few years ago, started e-courts, and I was most happy about this. Oh, well, we have e-courts now. It will be accessible to many of us, especially the blind people. But when I saw the practice, it was again a scanned document. And only thing was that, in the index, you were sort of making it, when you clicked in the index, so you would be able to go to various pleadings. For example, you will be able to go to certain applications, you will be able to go to main petition, you'll be able to go to annexures. But what is written in the annexure is only a scanned copy. So none of my blind friend or a blind judge or they would be able to understand. So even e-court system wasn't really meeting the requirements of accessibility the way it was implemented. Perhaps the knowledge or the awareness did not exist when it was being implemented. One more issue which is coming forward is a lot of stress is being given by Supreme Court is live streaming of hearings. Live streaming would be that if there is any case which is not very personal, where not very personal details are there, so a PIL or a general case, there could be live streaming of what is happening in the court. And there could also be captioning, or they could be also whatever happens in the court would actually be reduced into a kind of description. So what all discussed would become a part of hearing. So this is already agreed in principle by the Supreme Court, and many courts have already started to do it. The live streaming of hearings, it is becoming very, very a good practice, and a lot of lawyers are getting benefited, clients are getting benefited in live streamings. The only thing is the live, I would say, a sign language interpretation isn't still available. But yes, you could hear the people who are not deaf probably could hear it, and they could benefit from this. Blind lawyers and litigants can actually benefit from it. General public can also benefit from it. In virtual access, another area of access to justice is, how do I know what the orders were passed? So is my order in my case available to me next day or the same day? Or is the judgment available to me? Is it accessible?
Subhash, one second, I'm so sorry, I missed
Please.
the first sentence you said. Is something available? The first
orders and judgments that are pronounced by the courts, are they available to the clients with disabilities or lawyers with disabilities or general public who are interested in certain cases? So very often what happens is these orders and judgments are not in accessible formats. It does not indicate what all happened in the courts. It's just a two-liner, so-and-so present, next dated so-and-so. Lot of transaction happens, we did not know what happened. The lawyer will give us different story. The client will give a different story. Unless you are physically there, you won't get it. So live streaming, and those are good answers to this. But judgments and orders also need to be in accessible format. So that's another challenge that we are facing in access to justice, that we don't get most websites of high courts, of low courts, they have tried to incorporate accessibility, basic accessibility, but in many court challenges remain for blind people, especially. They cannot access the judgments. There is visual captcha on the website, and the captcha is so difficult to be negotiated. There was a committee which was e-committee headed by Justice Chandrachud himself, and some of our blind lawyers who were interning that time were actively involved in ensuring that this included accessibility in a phased manner. So this committee did send out necessary directions to all the high courts to make their websites accessible, and also look at how pleadings and various judgments could be made accessible, compliant with the ICT standard. I hope all of you are aware of the new standard that we have under Rule 15 of RPWD rules 2017. The requirement of website accessibility is already given. So all the websites need to be accessible as per the GIGW standards. So Government of India website standards, website need to be accessible. And the website accessibility does not mean only content, the written content, but also images, but also how do you access the website, how do you negotiate various menus, sub-menus, tags, are there heading, titles, can a person by using a screen reader can understand the whole, I would say, structure of the website and jump from one heading to the other? Is there a search option available? So there are so many components of accessibility. Can I use the website as a person who is, say, blind plus deaf also? Can I use the website, a person who's relying completely on mouse? So all these elements are currently a challenge, and they became further challenge when the COVID stuck. So literally, even judges, most judges, especially the senior judges, they felt it was a Herculean task because they were so adept to seeing the people in front, and suddenly the position. I mean, I can share in person. I won't name the judge, but then the judge shared that in the online hearing mode, I'm just another person in the court. I could not exercise my powers. I could not ask people to be quiet because there was no control. The control is with a technician. So in the court, you can ask a person who's speaking too much or not obeying the court's order. You could arrest the person. Contempt proceedings can happen. A lot of things can happen. But I saw in many hearings, the client would say anything. And the judge felt that he did not have control over, I don't know, this was a change in the whole system. The people are not really. So those are the experiences that came from them. But the accessibility is a major challenge. Then comes administrative hearings. There are a lot of, within the access to justice system, there are administrative hearings. Now, for example, any person with disability eventually would be going to hire a lawyer. Lawyer's fee is very costly. So that is another barrier, practical barrier. So what happens? They end up going to the legal aid clinics or legal aid cells that are created in different courts. So I'm sure you are aware of the laws on the National Legal Services Authority Act. So under that act and the state legal services authorities, so these are constituted under the Legal Services Authorities Act of 1987. So it's National Legal Services Authority and State Legal Services Authorities. They both are created under the Legal Services Authorities Act 1987. So under this act, there is a provision to provide legal support to persons with disabilities as one of the disadvantaged groups. So you can actually avail a lawyer from this authority, which will be free of cost to you as a person with disability. So in fact, our law also talks about I think in section 12 itself, in section 12.3, that the provisions would also include reasonable accommodation of this Legal Services Authorities Act. So that means any person with disability would have access to any scheme, program, facility, or services that are offered by this authority to persons with disabilities. So in this, what happens, the practical experience that we have is there is no system of, there's no awareness among persons with disabilities about how to get a lawyer who's competent. These authorities very often have a list of lawyers. So when you go there and you are accepted to be a recipient of that scheme, you're considered, yes, you are eligible to get a lawyer because you are a person with disability. A lawyer is assigned to you. But then these lawyers are not trained in disability equality, disability sensitization. They don't know how to interact with persons with disabilities. Again, sign language, the language communication becomes a huge barrier. It is much more with people who have, say, conditions like psychosocial disabilities, or families who have members with intellectual disabilities or learning disabilities. It becomes a huge, huge challenge. And the worst challenge that I found is they aren't aware of the act, the rights available under the act. And the judgments over a period of time that Supreme Court and the High Court and have actually pronounced, they aren't aware of it. They're not really, they really do not have mastery over the disability subject. So what happens is, because of that, despite a lawyer representing the person, the right arguments do not happen. And very often it is said that a lot depends on which bench your matter goes to, or how sensitive the court was, or how aware the judge was. In fact, our law talks about raising awareness of not just parliamentarians and members of legislative assembly and police, but also judges. So because while we are framing the law, we knew the judges do not know about disability law. While creating policies or formulating judgments, they are not aware of the law or the rights or the principles on which that the law is based, this beneficial legislation is based. Because of that, many a times there is subtle discrimination. Though there is a very good and very strong case, it doesn't get the intervention or the focus that it deserved. Another major issue is the time taken in the justice delivery. So that renders the entire access to justice effort, which is futile. To get one thing challenged, I'm waiting for 2 years. I can give you an example. I challenged a case of employment, where I was challenging the employment notification, where the reservation wasn't given for the deaf category and for orthopedic category as electrical engineers in one of the organizations. It's a mining company again. It took about 1.5 years. And by the time the organization had already, processed with the whole system, they identified people, selected people, and they said, well, we can't do anything now because we can't stay it, we can't stop it. And those people have already need to be appointed. And so therefore you better try next time. So we'll give reservation next time. So these delays, sometimes even when you reach the court in time, the long queue of people, though there are circulars which will say you need to give preference to cases of persons with disabilities, of elderly people, but they do not get that priority in listing of these cases. Arun?
Sir, please spotlight me. This is Preeti Sapra, another sign language interpreter. I also
Okay.
text on a group. Yes.
Okay. I'll just wait until you are spotlighted.
Yes, sir. Please continue.
Okay. So we were at coming to section 12 of which is under the RPWD Act, where I was talking about access to justice. So there is a section 12 within the RPWD Act 2016 that talks about access to justice, and it actually underlines that the government shall ensure that persons with disabilities are able to exercise the right to access any court, tribunal, authority, commission, or any other body which has judicial or quasi-judicial or investigative powers. And what is the condition? Condition is without discrimination on the basis of disability. So I should be able to access all these legal forums without discrimination on the basis of disability. And if you remember, we had studied that denial of reasonable accommodation would constitute or would amount to discrimination on the basis of disability. And my major question here is, currently, none of the courts currently have any system in place for this reasonable accommodation. The law also provides that the government will take steps to put in place suitable support measures for persons with disabilities, especially those who are living outside family and those disabled requiring high supports for exercising legal rights. Now, this is another plethora. People living outside their families, for them, there are absolutely no declared support measures in terms of access to justice or how they can get justice. Most people, when it comes to their rights, routinely, especially most of the people that come to me are not just talking about employment. Many people come to also say that my justice has not been done with me, my family has not given me my share of property, or my brother has just taken away my property, a family member has just taken away my property, and I'm literally giving us some money to just sustain myself, not my share. I'm not allowed to handle my finances or my property. And people do challenge these. So this is also connected to right to legal capacity, because all these sections are connected to each other. I can't see you, Divya. Are you still spotlighted?
Yes, I'm spotlighted.
Okay. You're not, certainly not visible. Fine. So section 12 does talk about supporting people with high support needs, but the law also creates a system of assessing people with benchmark disabilities to be assessed as persons or certified as persons requiring high support needs. Even after, or it's almost like 5 years, more than 5 years, that the Act came into being in 2017, we are in 22. We still do not have boards who will assess persons with high support needs. So persons out of benchmark disabilities need to be assessed and certified that yes, these are people with high support needs, and they need to be given these support measures. So there's a huge vacuum. We haven't really worked on these areas as governments, as NGOs, as activists, as stakeholders. And I always say the best of laws can remain in statute books if we are not addressing or if you're not actively involved in invoking various sections of the law. Now, section 12(2) is really not implemented currently. So we don't have systems, we don't have any declared policy on what these high support, how you would provide support to people requiring high support needs. In the first place, whether there are people with high support needs who are certified to be so. So these, we are still there. So it's like, chicken and egg situation. So since I'm not certified as a person requiring high support to exercise my legal rights, there is no mechanism created in my access to justice. And this, as lawyers or as people interested in this area or activists, this is an area where we can definitely look at how do we initiate these mechanisms and get these mechanisms created by maybe filing a PIL or maybe taking up this matter. I'm sure all are so engaged into their own rights that many of these sections of the law have remained unattended. Section 12(4) does talk about under the access to justice that the government shall ensure all their public documents in accessible formats. They will ensure filing departments of the courts, registry, or any other office of records. They are given necessary equipments so that filing, storing, and referring to the documents and evidence is enabled in accessible formats, so that I can, use this the mechanism to get a certified copy, which is an accessible format of my judgment, of an order, of an application, or of a case. Then if it is stored in, I should be able to get in multiple ways. I should be able to get a e-text format copy. I should be able to get a braille copy. I should be able to get a accessible format of copy. So because these all are identified as communication in the Rights of Persons with Disabilities Act. I'm happy to tell you that the Delhi High Court actually issued a circular in November 2021, wherein it actually said, it was circulated that Honorable Chief Justice, on the recommendation of Information Technology Committee, because every court has an Information IT Committee, and they ordered that uncertified copies of braille printed copies will be provided to users. So that was a circular by the Delhi High Court. And I can tell you that people with blindness, as lawyers or as litigants, they could obtain braille printed copies of the, but they will be uncertified copies again, not certified by the code of law by stamping, but they will get these copies braille printed from the court. They just have to submit an application for obtaining copy. It can be also done online. And I think a small fee of ₹5 is a court fee that is needed. And the charges are ₹3 per page for a braille printed copies of the order. So few courts have undertaken these measures so that this is, but then I see that these are tits and bits. They are not really they do not provide a wholesome experience of access to justice to a person with disability who has, say, vision impairment. I'll come to how persons with disabilities can not just be litigants, how they can exercise their rights as judges, how they can equally participate in the access to justice system as lawyers. So I remember, I think about in 2009, I was writing a piece. Probably I also put it on my blog, and the article's heading that I put was, "Can a blind or visually impaired person work as a judge or a magistrate?" And what led me to write this was that I had taken up a case of a person with low vision who was a practicing lawyer and wanted to become a munsif or a JMF or a judge in Kerala. And he was denied, saying that you are blind, you cannot become a judge. And we took it up in the court. And subsequent to that, I think there was a notification that yes, low vision people would be allowed, but not blind again. And I gave a detailed presentation to the court. And the judge was pretty impressed as to how a blind person could be able to work as a magistrate. And this question I very often face. And I told the judge that there is no impediment in appointment of a blind as a judge or a magistrate or a munsif, because the post is identified by Government of India. Now, secondly, there is also reservation for persons with disabilities, especially for blind. And I remember as in 2007 itself, when the identification of post was published, the post of judge was identified for blind in the first identification portion in 2001 and subsequently also in 2007. But there was not a single appointment till 2009, and we were wondering as to why this is not being done. And the court said, yes, are there any role models? you're saying blind can be judged. Is anybody working? And then I brought to the court that yes, in our country alone, in our country itself, if you remember Mr. Sadhan Gupta, who was the additional Advocate General in Kolkata, and he remained Advocate General for almost 7 years, and he was completely blind. And it did not deter him from performing his important and sensitive job very effectively. And neither the government thought that he was incompetent. So, and similarly, there are many other examples in around the world. If you look at in Germany, Dr. Heinz Eugen Schulz was, who retired from judiciary. He was very functional judge. We all know about Justice Zakaria Muhammad from South Africa. He visited India. He was actually judge of Constitutional Court of South Africa. Constitutional Court is very important, holds a very important position in the country there. And he was in India advocating for rights of persons with disabilities. So the reason why we did not see blind people as judge was, I think this matter also came up in the Supreme Court, where in the first instance, the court said, no, blind people cannot be judge. So they need at least some vision so that they can see, clients, they can understand this, his conduct and, body language and what all. But subsequently, if you see Justice Chandrachud and the other judgment in Vikas Gupta, it is in Vikas Prasad, if I remember, in Vikas. The court said, no, this doesn't work. Reasonable accommodation is the key. And in the earlier case, reasonable accommodation was not looked at. So, we feel it's a failure of system, which has actually made no efforts to sensitize the larger population about abilities of persons with disabilities. See, this is an era of technology. And, the power of screen reading softwares, it has reduced the functional impact of visual disability. And you see, we see that in many other countries, newer technology, where people are using tongue as an eye and they're exploring. With a tongue, they're able to use the computer. The second issue which we felt was the blind people and other people with disabilities were not really trained into legal courses. And in fact, this also goes back to one important case law where a girl with physical disability who was refused hostel facilities, saying that they are not accessible in one of the law courses. And this matter went up to Supreme Court, and the court ordered the Bar Council of India that what are your conditions to give licenses to these or affiliations to these law colleges who conduct these courses, why they're not accessible. If the post of judge is identified for disabled people, if they can't study law, and if the institution is not accessible, and if they can't study, how will they become judge? Or how will they become lawyers? These posts are accessible. The posts are identified. So then in that case, if you remember that important case, the court actually directed the Bar Council of India. Bar Council of India changed its affiliation rules, where it incorporated that every institution need to have accessibility in the class, not just classroom but also in the hostels. So you need to provide wheelchair access, you need to provide access to blind, you need to provide things in alternative formats, in accessible formats. So all that was ordered in that case. There are, within India, I can tell you about Tamil Nadu, where one Mr. Chakravarti was, he was a practicing lawyer. He became a judge in the country. And then I think in one more, in Madras again, Mr. B. Veerakumar, there was one blind advocate. So we have found people with physical disability at many places because as judges, but not blind and deaf people to be advocating or to be doing advocacy or to be practicing as lawyers. Because many people think deaf people cannot become lawyers, but deaf people cannot become judges. They very well can. How we have addressed this issue? We haven't provided any reasonable accommodation. We only look at what person can't do. The system is so biased, and that's what I call it, discrimination on the basis of disability. How society perceive persons with disability. So this is something that needs to be, and the road ahead that I find is, we need to create systems so that people are encouraged, all disabilities, to take up law as a subject, and to be supported in preparation of their exams. Systems are there already to support persons with say scheduled castes and scheduled tribes. So similar provisions also exist for disabled people. So in access to justice, we need to train people so that we see more persons with disabilities. And I always quote this example, and I quoted this example from New Zealand. The parliament became accessible and adopted sign language as an official language in New Zealand because there was a person as a minister who was there and whose rights they thought could not be infringed. He had equal rights. So we need to see persons with disabilities in important positions in access to justice system, as police officers, as advocates, as lawyers, as judges. And then perhaps system things would fall into place, because when people are there, then they know, yes, people are here. It's like, again, chicken and egg situation. I always say that because people are not there, you don't make it accessible. So now people are there, please make it. So that perhaps these are the solutions that perhaps we need to think, and we need to push, and we need to enable. NGOs can sort of take a lead role in training. Government definitely can come out with schemes to train persons with disabilities to fill up various roles. A lot of training is required for police departments and for judges. One more issue in access to justice that I want to bring to a notice, and which is the use of right language when a judge writes an order. How do you refer to persons with disabilities? As crippled, unfortunate person, a wheelchair bound? I've seen these terminologies. I'm telling you on record. I've seen these terminologies. I'm sure you also must have seen in the court orders. When the court writes the wheelchair bound or deaf and dumb, what is dumb? Why do we use these languages in the? So judges need to be trained on use of right languages. In fact, I was doing a project, some of you can refer to it, it would be soon made available, where I did research of some hundreds of judgments, looking at how a sensitive judge uses a right-based language, and people who are not exposed to it, they use this kind of patronizing and in a condescending language. So this, we have to start there, because language has the power to impact your thoughts. As the thoughts have power to impact your language, it's also reverse. Also, it is applicable. So what you need to do is get aware. We all as sectors can work on it and create awareness. We were conducting, and I'm sure through legal services authorities, a lot of organizations are already conducting awareness sessions for judges. I personally conduct trainings for many of such civil servants, including engineering officials. I conduct trainings in the National CPWD Academy to train people, architects and engineers, on design, on disability etiquettes, on accessibility. In fact, in Delhi, the Delhi Commissioner for Persons with Disabilities organized a training for member of legislative assemblies. All MLAs were trained on disability rights in a session by the Office of Commissioner, because this is a mandate under the law. The state need to train the police official, the Gram Pradhans, so that they can, so entire, I would say, system need to be made aware and shown the possibilities of persons with disabilities as not as active contributors and active participants in the access to justice system, rather than being passive recipients of services, people who are suffering, who are shown as people suffering from disabilities. Incorrect language. We need to really check that. So What other things that we can do to have more people act into this area? For example, I just quote one example of how can a person become a judge and a lawyer. Provide him a talking software. Gadgets like accessible laptop and accessible mobile phone. All petitions, applications, written statements, replications, rejoinders that we file, affidavits that we file, all documents that we file in the court should be in e-format. When I say e-format, not the e-code concept of scanned copies, but some documents that are compliant to Rule 15 of RPWD Rules 2017. So they are in e-text format. They are in e-publication format so that my screen reader can use it. Then all evidential documents like affidavits are filed, all evidences that are filed in the court, even if they're legible, they must be compulsorily submitted in typed copies. Once you can, I very often say, once you can do it for High Court judges, anything that is written in any language is translated into English and submitted in the court of law in double spacing in typed version. Why can't you make it its e-text format or simply a Word file or text format it is given to them? It will make it accessible. You're already doing it. Why can't you do it for enabling inclusion? It's simple. Most of these High Court and Supreme Court judges are elderly and they have low eyesight. Something which is available in regional languages and is written can also be translated in English. And this will make a lawyer or a client or a judge to be efficiently functioning. There are libraries in the courts. This legal library, these are attached to the courts. Can these, we have traditionally seen mota books, legal books, IPC and many laws and commentaries on various laws. They are always, you will see in the background of lawyers, in the chambers, in libraries. None of them is accessible. Can we have these in e-text version in the libraries for all the legal books and reference books, which a judge can refer to or a lawyer can refer? Similarly, all these case laws that we have, digests that are published in the legal system, the All India reports, can they be, of course, many of them are being made available in CD formats. They can be made available in e-text format and to the judges. But I found in form of CD, what they're doing is they're simply scanning the old judgments in picture format and circulating. No, that's incorrect. They need to be in digital formats, which can be read by screen reading software. So, what is needed is an open mind, accepting and understanding that people with disabilities can perform, have abilities, can perform on equal basis with others, provided they are given reasonable accommodation and equal opportunities to participate in the justice system. So that's, I think I'll stop there and I'll be open to questions. I've said enough. Just any question, I'm open to questions. If you want to put them on chat box, or it can be just, you can unmute yourself and
Sir,
yeah.
I had a question.
Mm-hmm.
I was wondering, do the law students have any subject pertaining to disability studies or anything of that sort? Because ultimately they have to deal with disabled people in their career life at some point.
Did you name yourself?
My name is Saji Ghosh.
Okay. Saji Ghosh, thank you, Saji, for this is very important question. And I think this question is not only important for the legal area, but also for all professions. And I can say from my experience that the Government of India's policies on inclusion are very, and the new NEP, also the earlier policy where we spoke of the education policy, did talk about of adding concept of accessibility or exposure to disability sensitization from the school stages itself. So if you go back to the NCERT books or the CBSE curriculum, or you'll find in every subject, especially in languages like Hindi, English, social studies, especially in Hindi and English, you would find a story about a person with disability, blindness or some other disability, and it talks, the lesson is written from their angle. If you have time, if you have siblings who are younger, just look at their books and you'll find definitely positive stories are being included from the school level itself. The NEP also, this current NEP also talks about introducing sign language at the pre-nursery level. So you include people with who use sign language from that level itself, so that there is more inclusion happening. Because otherwise we have seen person with who are deaf, they remain alien even in their own families because nobody knows sign language. They learn sign language, so these people hang around with their friends because they are so conversant. Everybody speaks good sign language, and they become alienated with their own families. So sign language has the potential to integrate, and of course knowledge of disability rights. So yes, I completely agree. In medical field, yes, there is disability competencies are being added as an essential subject to students with who are studying medicine. Similarly, for architecture, yes, the architecture and civil engineering, accessibility and disability sensitivities and disability exposure is ingrained, but it is very basic. It's very basic, and since I have conducted certain such courses for architects and for civil engineering courses, I found this is currently only as an additional subject or an optional subject. This needs to be a mandatory subject, and disability studies should actually become a mandatory subject. And in fact, not just disability, I'm sure diversity inclusion, the DI, should become a necessary subject in all professional courses, and in fact all graduation courses also. I can just tell you that we were as a member of this University Grants Commission, who was writing, the expert committee who's writing and currently reviewing the standards of accessibility and guidelines on harmonized, I would say comprehensive guidelines on accessibility of physical environment, pedagogy and curricula. So we have incorporated this particular question that you just said. We are talking about, and the national policy also says that all universities must start a department of disability studies. They're encouraged to start disability studies, and this can also be cross-linked with many other studies like arts and social sciences and people who are studying different subjects. In fact, the new NEP is so creative that it allows a person who's studying science to also have subjects of his choice from other streams as well. So as a person who's studying science, you don't need to remain aloof from what is being taught in the economics. So you can take economics also. So the new NEP is addressing this area, but I think I would agree with you that it has to be a mandatory subject rather than being an optional subject. Completely agree with you, Sigi. Sigi.
Thank you so much, sir, for giving us so much insights. And I really think that had I not asked this question and had I just kept it to myself, I would not have had any idea that so much has been in the background has been happening. And this is all so new to me and very interesting as well.
Lovely. So good to hear. And that's why I always say, pooch lo, maang lo, because unless you ask, and I always tell to persons with disabilities, I keep telling, एक माँ भी अपने बच्चे को तब तक दूध नहीं पिलाती जब तक वो रोता नहीं है, जब तक वो मांगता नहीं है, So you need to ask, you need to seek, you need to question, you need to raise voice. So I always ask people to verbalize their demands, verbalize their needs, whether it is reasonable accommodation or equal rights. Don't suffer in silence. Please raise voice. These are your rights. I can see in chat box there are 3 chats. CG, you said this makes me think of a lady justice and how the blindfolded signifies fairness and impartiality. Okay, thank you. The concept of justice being blind, Arun says the concept of justice being blind, center and focal point of justice. Okay. Any questions in case you want to add here or you want to ask? More questions, please. But I can relate one incident of I think early 2006 or 7. It was a time when Delhi High Court had no posts, and in fact in Delhi there was no reservation was given for persons with blindness in judiciary. And despite the identification list of 2001 being there. So in one of the judicial colloquiums being organized by the Human Rights Commission along with Human Rights Law Network in Delhi, I happened to be participating there with one of my blind friend with whom we had started and in fact formed the advocacy cell of the All India Confederation of the Blind. He himself was Deputy Director in Ministry of Labor, and he was 100% blind. And we were there as a part of this judicial colloquium where there were Chief Justices of several high courts and several senior judges of high courts. And also I remember 2 judges from Supreme Court. And we raised this question that the post of judges is identified for blind. And the blind people also are very closely, I mean, of course, it was just said in a joking way by Mr. Rastogi, who was incidentally with me, himself a person with blindness. His name was M.K. Rastogi, himself blind. He said that the Devi of Justice is blind. I mean, it's often said, and the blindness probably there is said because you don't favor somebody by opening your eyes, it is probably said in that perspective. But then he said, yes, we are very closely linked with the view of justice, and why blind people can be good judges is this Devi justice itself is a huge example that how blind people as judges would do much better because they won't be biased, merely by looking at people. And this was so impactful, this intervention during a question, that the judge, I remember the name of the judge was Mr. Bhatt, and he rose to be a Supreme Court judge today. I mean, he is in the Supreme Court. And Mr. Bhatt, 3rd day, he got issued a notification, a corrigendum to that vacancy notification. And the 3 posts for judges in the lower judiciary were reserved for the blind people. And that was so amazing to see that with this small orientation, you need to ask, you need to tell, you need to raise awareness, and things automatically happen. Yes, more questions?
Yeah, so this is Ashwin here. You touched something about use of offensive languages in many judgments. So could you elaborate more? I was just curious, to know.
Okay, thank you. So won't call them offensive, but then, we are talking of a right-based language or a language that does not, I would say, that promotes person's first language. So I'm sure all of you, if you have already attended one of my earlier lecture, I don't know whether I did with this class on sensitizing on disability. Did I do first time if you are attending that? So we spoke of the terminologies that we need to use and not use in a certain way while referring to persons with disabilities. So a simple example that I give is, how do you want to be referred? I give you, even without, let's not talk of disability for a moment. Let's say, would you call somebody on, because I mean, would you call or name somebody or invite somebody or refer to somebody on the basis of his caste? It's offensive, right? A recent example we saw in this award ceremony of where somebody's baldness was made fun of, and you saw what happened in the Oscar stage. Yeah. So anyway, that was an extreme. But then what I'm trying to say is, we use a language that is not offensive. We use a language that is persons first. And persons first approach is, when you refer to persons with disabilities, you will see I consistently have used the term persons with disabilities. That means there are persons first and then their condition. So we don't say anybody Langda or Lula or Andha. They have a name. And then if you are referring to them, they're persons with a certain disability. We don't call them by their disability, but there's a name. Or if you're by referring, they are persons and then followed by. Similarly, the way you don't call any person by his caste, So I can, another question for you, that is, what is the right terminology? And my answer to that would be, whom you are referring, ask that person, how does it feel to him? There was a time when blind people would accept being called as surdas, and other people would feel that this is a better word than calling him andha or blind or whatever. So surdas was a more respectable word at some point in time, because surdas was one poet who was blind, but then he achieved mastery and became a very celebrity poet and very successful poet. But then even surdas became a term which was given by others to that person. Another term that was given by Gandhiji, the father of nation, to people, those days they were called as untouchables, or whatever language. I mean, the languages were used were in reference to their caste. Gradually, the constitution, gave them another name called scheduled caste, and scheduled caste actually meant that some castes which are mentioned in the schedule to the constitution. And the Gandhiji gave them a name Harijan. Well, it may have been a very good meaning term being given to them, but then people did not like it. People said no. Today, if you ask any person, they would say, well, I prefer calling as Dalit rather than being Harijan or even persons with disabilities. It's always good to ask person. Many people are better, prefer calling them as deaf, and some would say, no, you call me as a person with hearing impairment. Similarly, many blind people would prefer calling them as blind, it's okay. And some would say, no, persons with visual disability or vision impairment is okay. So it's again very individualistic, very individual, but the terminologies which very often relate to where you show them in very condescending ways, or you show them in very poor light. For example, if I'm referring to a wheelchair user as wheelchair bound, that's a wrong language, because language is important. If I say wheelchair bound, it means I am bound. You make somebody housebound. It means he's a house arrested person. Wheelchair bound means somebody is tied onto wheelchair by force. On the contrary, a person who's wheelchair user, it's his independence. It is his mobility. It is his emancipation. Similarly, when you say, in the judgment, when the judge writes, the person the poor or the petitioner is a person. I can quote certain. I'm sure this will soon be up on my website, the subhash.com, and also on disabilityrightsindia.com. Very soon I'm going to put the publishing it there. But then you can find many orders there also where the judges have used these terms, that afflicted with polio. What is this term called? You could have said a petitioner is a person with disability, and in bracket you could say polio, or person with polio. Or PPRP is a short form. It's called post-polio residual paralysis. He's a person not suffering or stuck with or crippled. All these languages are wrong. They need to be person's first approach. That's what I meant when I'm saying. And also, when you're writing a judgment, the judgment must promote the right-based language and right-based philosophy also, rather than charity-based. The poor people, they should be given this, and please consider this. That kind of language I'm really against, and I have actually written also in my lot of pieces on my own blog, where I have taken on, in fact, reflected on these issues of how judges can be a little more politically correct and use right terminologies, because what terminologies they use can impact how people and authorities against whom the judgment is passed, the duty bearers, look at persons with disabilities. And this is very important. I hope that that helped.
Hello, sir. Am I audible?
Yes, you are.
Sir, good evening. Sir, as today you talked about access to justice in courts or in administrative levels. But sir, look at means if I am not going in courts but sir, in universities or colleges or in schools, we have seen those panels or committees which have been made for some cases. Suppose that I want to share an incident that happened with me, sir. I'm also a visually impaired student. So 2 years ago, I was in a hostel, and one night I was coming from outside, and one person hits me, means one or two slaps on my back of my head, and
Okay.
sir, and when I means called for help to the guard, I was alone there at that time, and the guard says, "Why anybody will hit you? What you have done?" So I have to defend myself that yes, I am a victim. So and when all the wardens and all the administrative officials came, and they again asking, हो सकता है किसी ने मजाक किया होगा. But so but I am fortunate enough that there was a CCTV, and they saw this that a drunk man coming from inside from the hostel, and he really hits me and given means and done
Who was that
everything.
person finally? Who was that person?
He was an outsider, a friend of some hosteler. So that hosteler was with immediate action was been rusticated from the university, from the hostel, or his door was means his room was taken by the administration. But I want to say that I have to defend myself that due to lack of incidents, sometimes we suffer.
True.
And yeah, and so disabled and non-disabled perceptions means the perceptions of non-disabled, that they always say that I am means a person who is disabled has not done anything harmful to others, so why anybody will hit you or do anything harmful to you. So that's
True.
also a means very serious problem that I have seen. Yeah. So
thank you, Abhay. I think you did touch on an important area of legal capacity and how people have those prejudices, because when I started my talk, I did talk about the major issue that we are discussing was the prejudices, because discrimination, when I said what is discrimination in access to justice, I did talk about, I remember, the bad treatment on the basis of prejudices and stereotypes about disability. And this is so pervasive, it is so deep that we really need to address it by awareness, one. Second, quasi-judicial, judicial, and police stations. I did not talk about the jails. In fact, that was another important area that I wanted to touch upon, but I said there's no time. But then accessibility and reasonable accommodation in people in jails, in people who are incarcerated in police stations and in jails also is an important area. I was helping the Ministry of Home Affairs in finalizing a guideline, accessibility guideline. I don't know whether you have seen and whether you are aware.
Yes,
but
sir.
Government of India currently is under the leadership of the Honorable PM is there is a lot of focus, and the Honorable PM has himself given clear instructions to the Cabinet Secretary, and all the departments and ministries are tasked as a priority area to prepare their guidelines, comprehensive guidelines regarding the domains that are under their purview, to write and to publish accessibility guidelines. When I say accessibility, they are actually that would mean not just built environment, but inclusion guidelines as to how they will include persons with disabilities in various activities, schemes, plans, programs, and whatever that they do. So UGC is one agency which is Ministry of Higher Education. Ministry of Education is currently doing. So I'm sure you all must have received those guidelines, and many of you must have also responded with comments on what to do in this. Similarly, Ministry of Sports has come out with guidelines as to how they will make sports infrastructure accessible for persons with disabilities of different kinds. Ministry of Aviation, Ministry of Railways has come out with their guidelines. How will they make their infrastructure and services accessible? How they will make their applications accessible so that people can independently book their tickets. So I'm just giving you examples. So Ministry of Home Affairs also drafted these guidelines, and as I in fact reviewed about 3-4 ministries guidelines as an expert of Government of India, because these guidelines have to be published and finalized in consultation with Office of Chief Commissioner as per Section 40 of the RPWD Act. So all these ministries are drafting these guidelines, sending these to Commissioner Disability as for consultation, and the consultation with Commissioner Disability would eventually have experts on their committee to help the office to review those guidelines so that their guidelines are in right earnest and are are they meeting the objectives that are of Accessible India campaign and of the laws. So just to give you a reference of what we did and what Ministry of Home Affairs did was that they also prepared a detailed guidelines on how to make police stations accessible, and they gave detailed designs of police stations accessibility, and it did talk about sign language interpretation services in police stations as well as in jails. And so these were already part of guidelines, and I'm telling you these guidelines would be published in the coming days, probably later this year, as rules under Section 15 of RPWD Act. So RPWD rules, Section 15, they will be published, and then all persons with disabilities will have a right to complain and say that these are my rights and they were infringed, they were not met within the time period prescribed, and they can go in the court of law. So the Prime Minister and this government is actually trying to make this law really work, because earlier for every damn thing, it was only Minister of Social Justice who will be responsible, whether it is education of disabled, whether it is access to justice, whether it is sign language, whether it is health or rehabilitation. So everything has to be done by welfare. So approach was welfare oriented. Of course, subsequently the name got changed from welfare, they became Ministry of Social Justice. And subsequently another awareness that came, they said, no, not just social justice, but also empowerment. So the department's name was created as Empowerment of Persons with Disabilities. So we are at that level, empowerment of persons with disabilities from the welfare. However, the involvement of various ministries to devise guidelines of areas that are within their domain is something where the awareness of various ministries is also getting raised. A few days before, I got a call from certain ministry that I'm speaking from this ministry, sir, we need your help. We want to put you on that committee, expert committee, so help you, do this accessibility guideline for my ministry. And I was surprised that they were not really aware of what they have to do to include persons with disabilities. They said, we are from this ministry, we don't have anything to do with accessibility standards, because for this, there is a Bureau of Indian Standard, then there is Ministry of Housing and Urban Affairs. So they will do about this. And for accessibility in ICT, there is Ministry of Information and Ministry of Electronics and Information. So they will do about this. So we are not concerned, but then we have been tasked to do. I said, man, you look at your ministry. For example, Ministry of Rural Development, I give you an example. What will Ministry of Rural Development do to ensure that there is access to justice or justice is done to persons with disabilities? They'll have to include accessibility in all housing schemes that Ministry of Rural Development under various schemes where you're giving housing to the poor and in disadvantaged section to minorities. So persons with disabilities also is one of the minority or disadvantaged section. They have specific needs. So how can this ministry ensure that when it comes to a person with disability or in general, all the housing that they make are by default accessible? They have a wider door, they have a larger toilet, so that elderly people, pregnant women, persons with disabilities, if at all there, they are able to get integrated, included in those housing schemes. Now, rural development might be building toilets in rural areas, might be building connectivity to the rural areas, to villages. And how do you ensure accessibility for mobility impaired people? Can you make it? The example is that during rain, people with disabilities cannot come out of the villages to the nearest road. So how Ministry of Rural Development can include the needs of persons with disabilities in all their programs and schemes? For example, Rural Development has a program on Adarsh Gram Yojana or Ambedkar Gram Yojana, where a certain village is adopted and huge fund is introduced for creation of roads, public toilet, this, that, lighting, etc., and modern amenities, internet, and other things, supply of water, drinking water. How can you make the concept or the scheme of inclusive village or Adarsh Gram accessible village? Now, this is what is the objective of the Prime Minister. How each ministry can ensure inclusion. So it cannot be only the Ministry of Welfare or Ministry of Social Justice. Each ministry, education, they have to do their own. So you will see CBSE has come out with a guideline. ICT guidelines have already come in. UGC has done it. AICT is already almost there in final stages of doing it, or they've already done it. So all these institutions are publishing, and because this law, which I keep referring to as Persons with Disabilities Act, as a legislation which has created two classes. One is the duty bearers and one is right holders. And persons with disabilities are right holders for the first time. And Government of India and various governments are duty bearers. So various, you will find in none of the other act, the government is mandated to do certain things. Most of the time, all the laws are to regulate people, to regulate institutions, to regulate others. But it is for the first time where the government has become a duty bearer. And persons with disabilities are right holders. And that is the major reason when I go as a lawyer in courts, what happens? The first thing that the minister, when I challenge a certain, rule or certain, I raise a certain disability right issue, the first statement that the other side makes is, Your Honor, we are not taking this litigation as adversarial litigation. We are with the petitioner. We are helping them. So we will ensure that we come to assist this honorable court and provide. That is other thing, they will go to all extreme to oppose you. But the first statement that they make is that they are not taking this litigation as adversarial. Yeah. Does that help, Abhay?
Yes, sir. It will really helpful for every person with disability. And
yeah, also people like you who are actively working for that area and interested in fact, in UGC document, I tell you, we have also created, if you have read that, we have also created grievance mechanism or grievance redressal mechanism where people can approach their own universities. If that doesn't handle, they can come to district committees which are created under the act. If they don't act, they can come to UGC. They can come to State Disability Commissioner. They can go to CCPD, depending on whether it is a central university or a state university. So we are multiple channels, multiple focal points are being created so that rights are not infringed and people with disabilities are enabled to speak for their rights, verbalize, wherever there is infringement. Because unless you say, people, I remember until some time ago, every public bus, you'll find some of the other, foolish person would be smoking a bidi.
Yes.
Yeah. So then people said no, or every DTC bus will have written Dhumrapan Aparadh hai. It is written in all the buses that it is a punishable offense, but still people would do. And it only took some people to raise a voice, say that no, you can't smoke a bidi in the bus. And women would start, and then gradually it stopped. Now it is, but I'm sure in rural areas it still continues. But then it stopped in the Delhi transport buses. Nobody can. Of course, now with new buses and AC buses, nobody can. But then earlier it used to be a very regular practice. So you need to say no. You need to raise your voice for your rights.
Yes. So thank you, sir.
Yeah. Any more question? It's an interesting group. So. No questions in the chat box? Shakshi, Manvi, I find there are a lot of women also in this group. Shweta, Chainika Hazuri, Shivani. Any questions from women? Any participant who is a person with hearing or hard of hearing or who uses sign language in this group? Well, I think we are not getting any further questions. So I'm done. If there are no further questions, over to Akshay and the NCPEDP team. But thank you, Arun and Preeti. You have been wonderful interpreters. Thank you so much.
Thank you, sir, for such an insightful lecture today. We will be eagerly looking forward to the subsequent lectures with you. So the session for today ends here on this note. Please feel free to leave the meeting. Information regarding the next lecture will be intimated as usual through email and WhatsApp. Thank you, everyone.
Thank you. Bye-bye.